The following program is suitable for general audience of any age.
Tonight, we discuss cybersecurity and the law. What are the latest developments to the laws relating to cybersecurity in Sri Lanka, and are they adequately evolving to modern needs? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty here on Other Derana News channel, where we bring to you key legal concepts and break it down for the layman. Now, today's topic is not something that's new to us at all. We have been consistently keeping up with the trends and speaking about it. That's specifically on digital laws and AI, along with other technological advancements and how it relates to law. Specifically today, we will be giving a focus on cybersecurity and the legal impact that new laws have on cybersecurity, specifically in Sri Lanka. And to speak about this area, we have someone that's not a new face on the program and is very well equipped to give us the latest details. We're glad to welcome back onto the show Dr. Sunil Abeyratne. Thank you so much, Doctor, for taking the time to come to the studio here today. We appreciate it. A little bit of an introduction, of course. Dr. Sunil Abeyratne, apart from having extensive knowledge, as you have seen in previous episodes of ours as well, with multiple areas of the digital aspects when it comes to law, he's also the founder and the current chairman of the ICT Law Committee of the Bar Association of Sri Lanka. We will soon be having the ICT Law Conference as well in August. So safe to say we're at a very good spot with a very good person to speak about these specifics. Now, the way we're going to be approaching this program is as such. First, we'll be getting into the fundamentals to give you a bit of an overview of how exactly the cybersecurity space is protected by the laws in Sri Lanka. Next, we'll be getting into the practicalities and the current context, and finally we'll be talking about what we can expect as future developments in this area of law moving forward.
Hello, I am Sumya Ponso, an undergraduate from the University of Sri Jawaharlal, and my question is on fundamentals. What laws govern cybersecurity in Sri Lanka?
All right, well, without any further ado, let's get right into this discussion. Thank you so much once again, Doctor, despite your busy schedule, for making it here and for helping us understand this area of law. Now, before anything specific, when it comes to the legal technicalities, could you please help us understand exactly what the term cybersecurity means, especially when it comes to the legal perspective? Because at the current moment, cybersecurity is one of the most primary and most significant areas when it comes to governance and law.
Even under normal circumstances, when you exchange some communication, that means if you send a letter or any parcel or whatever it is, that you like to maintain security. That you must be confident about their letter or any other item. So likewise, when you say cybersecurity, when this is happening in cyberspace, we call this as cybersecurity. Under cybersecurity, it's a duty of the stakeholders to protect, secure all this electronic documentation, electronic transactions, storage. So this is the prime duties and prime obligations of the parties. So as far as cybersecurity is concerned, if you put this question to computer engineer or software engineer, that he or she might get some different opinion. And technology-wise, we can give various definition and explanation. As far as legal interpretations given, when you say cybersecurity, we can say it's a confidentiality, integrity, and retrievability. What is confidentiality? What confidentiality means, I'll take example, under normal circumstances, if we send a letter, the other party who received the letter must be in a position to confirm that it comes from so and so. And these contents are correct. These contents are not gone to another third party. And retrievability, of course, we don't apply much due to this. Postal department carry these transactions, or even telephone conversation, telecommunication mechanism carries this communication. But as far as the mechanism in cyberspace, especially online transactions are concerned, considering their nature and behavior, then we need the third requirement as well, that is retrievability. If you can't retrieve any document, now that is what's happening. Sometimes your friends or relatives or your officials will inform you. We send an email with an attachment. You will open your email. Email is there, but attachment is not there. So then this is happening due to some technical issues and various other issues as well. So therefore, this retrievability is also very important. So these are we identified these are the three pillars under cybersecurity: confidentiality, integrity, and retrievability. So this is what we are trying to fulfill. Introduce various regulations, rules, policies, laws. So even we'll discuss the other acts later. So in Sri Lanka also we have legal framework. We have lawmakers intended to give a certain amount of cybersecurity. So this is what is happening in other countries as well, even internationally, introducing various conventions, treaties, giving model laws to all jurisdictions, their member countries. They are trying their best to maintain this cybersecurity.
Exactly. And I think a very important point, as you mentioned, Doctor, when it comes to our context, legally speaking, as we have had previous conversations as well, it's not that Sri Lanka is devoid of a legal framework when it comes to cybersecurity and its insurance. If you could help us understand and clarify to us exactly what are some of the key major legal statutes or documents that exist when it comes to the regulation of the cyberspace and cybersecurity in general. If you could walk us through a few of those.
No, already we started to introduce a piece of legislation relevant to electronic medium or electronic contents, started from Act number 14 of 1995, Evidence Special Provisions Act. This act explain and try to give interpretation for electronic evidence, especially contemporaneous audiovisual contemporaneous evidence and computer-generated evidence. But these, the provisions under this act fit for that era. When you're considering the present era, we can say, because during that period we used computers as word processors. So there we can see identification and what are the conditions we have to fulfill when you bring any evidence before courts. This is also part of cybersecurity. Because if we don't take these steps, so we can't bring them before courts or any arbitral tribunal or other tribunals. So if it is so, there is no value of these contents. So then it's a prime duty of any party who wish to bring this electronic material before courts to fulfill this requirement. Then we introduced in 2006 Electronic Transactions Act following ancestral model laws. So there we can see especially Section 7 of authentication, electronic authentication part is there. That directly this section involves in cybersecurity. When you look at Article 7 of ancestral model laws and UN Convention on Electronic Contracts, because Sri Lanka is signatory of this convention, we hired this provision from those international piece of legislation. So there we can see international community try to maintain the cybersecurity. So next we introduced Computer Crime Act. When you look at Computer Crime Act, direct provisions are there to deal with cybersecurity. If any person break cybersecurity, then starting from Section 3 up to Section 14, we can see the provisions relevant to that, and second part explain what the procedure to investigate these offences comes under Part 1. And as far as these matters are concerned, international cooperation is also very important. This is what Part 3 of Computer Crime Act explains. That is in 2007. So thereafter, that what we can say still that it is not in operation. Then Data Protection Act introduced in year 2022 by Act number 9 of 2022, then brought amendment in 2025 by Act number 22. But unfortunately, still that we are struggling to introduce and enforce these provisions under this act. This act also we can see we have covered some parts of cybersecurity. Though the punishment is not involved in that, it's only administrative offences are there, but we can see check and balance and controlling mechanism is there as far as the personal data is concerned. This is also part of cybersecurity. Then at the moment, states trying to bring the Cybersecurity Act. The reason is, Anuradhi, we don't have separate Cybersecurity Act in Sri Lanka. Some countries they have. So that is why we have to pick various provisions from various acts, as I explained you, and explain what is cybersecurity. Well, at the moment, the Digital Economy Act is also drafting. So there are sometimes we expect some provisions relevant to especially as far as cybersecurity is concerned, the authorities will concern on that. So these are the basic statutes, basic acts, laws at the moment applied, relevant to cybersecurity part. But we have to go a long way. We need some regulations,
Yes.
policies to strengthen this legal framework.
Exactly. A question of curiosity building on your answer as well, Doctor. Since you mentioned we don't have a very specific cybersecurity focused single standalone act in Sri Lanka, do you believe that if we have an introduction of such a piece of legislation, it would clash with the existing pieces of legislation, or would it help to streamline the efforts more? Because we already, as you mentioned, we draw from multiple pieces of legislation. In your legal opinion, what exactly would it look like if we were to introduce a new act?
Because if we have this separate cybersecurity act, then Anuradhi, we have to think about the other acts as well, as you explained. Because we can't bring only cybersecurity act. That's interconnected. Then we must connect. If the proposed act is there, so we must connect the provisions with other acts. Otherwise, as you said, there may be some overlapping area. There can be confusion. Once again, there can be delays to enforce this law. To avoid that, we must do that very carefully if we bring separate cybersecurity act to deal with cybersecurity.
Exactly. Now, moving on to a few specifics relating to the acts themselves, if you could give us a little bit of an overview on the Computer Crimes Act, because as per my understanding, that is the primary piece of legislation we have that overarchingly covers most of the areas when it comes to online activity and electronic activity. Can you give us some of the few salient features that exist in the Computer Crimes Act and what areas exactly is strictly penalized? Because just to give the audience a little bit of an awareness into maybe some areas they wouldn't consider as being as illicit or illegal, but actually it is mentioned within the statutes.
Computer Crime Act in 2007, we can say it's a basic document as far as today's context is concerned. The reason is that in 2007 we identified few offences relating to computers and computer systems. Today, as far as the development of the internet and other networks concerned, we can see lots of new offences come to the system. So sometimes we may feel that that existing offences are not fit enough to deal with the present offences. Or sometimes we may feel that to reshape the existing legal provision. Anyway, that is up to the lawmakers to consider this matter seriously. That is one reason that lawmakers wanted to bring Online Safety Act to fulfill this requirement. As you asked, Anuradhi, now we can find 10 offences under Part 1 of Computer Crime Act. So they are starting from computer hacking, obtaining unauthorized access to computer system. So there you can see that directly, if you followed my interpretation given at the beginning, what is cybersecurity, then you can see if someone break security and entered into your computer system, it's a direct offense. It's a very, that sentence is very heavy. So then if any person obtain unauthorized access to carry further offense, to take example, to steal data, modify another person's database like that. So this will be a serious offense. It's explained under Section 4. Now Section 5 says any person sending program or physically or manually, or it doesn't matter the way, if anyone modify the computer or computer system, we call this as computer modification. Computer modification without getting the permission of the owner or person who is in charge of computer system, it's also serious offense. It explained under Section 5. We can find these 3 offences under Computer Misuse Act in United Kingdom. We hired these provisions from United Kingdom. But anyway, thereafter we signed Budapest Convention, Cybercrime Convention. Now there we can see some development. So anyway, that we didn't change our Computer Crime Act according to the provisions under Budapest Convention. But anyway, now it's an international obligation since we ratified and entered into Budapest Convention. Now starting from, come to Section 6. Section 6 says if any person misuse any computer system against national security, national economy or public order, then it's also serious offense. Now, this is a very, very serious offense. If the investigators carry these investigations properly and successfully, then you can reduce number of misuse activities today they are carrying through this network and computers.
Exactly.
Remember, the secretaries are attached to the particular ministry or the public security or finance ministry. If they certify that this is against national security or that of finance, this is a prima facie a valid document.
Exactly. Yes.
Then when you come to section 7, of course, uploading, downloading, illegal uploading, downloading, copying, everything is included. I don't know, Anuradha, you and I also, we have already committed this offense. As far as the provisions under this concern and under section 7 of Computer Crime Act. Now, section 8 says it's relevant to transactions, especially if someone interfere with traffic data. It's an offense.
Right.
It's already there. But only thing, you have to get a proper interpretation according to that present situation. That is up to the court, trial judge to give the interpretation. So section 8 is a direct provision. Then when you come to section 9, if any person use any device to carry one of these offences, it's also a serious offence. One rather, if someone asks to get illegal copy of the CD or pen drive, you can't just give your computer.
Yes.
Then you will also involve in that offence. So it's a direct offence under section 9. Now section 10 says, so there are instances to get down some goods or maybe services. Sometimes you have to enter into various contracts. So there you have to give a logon ID files and your password to the service provider. You have to feed these details to the screen. Then service provider will get this information. So after getting this information, it's a duty of the collector to give the maximum security. Maximum security. If the service provider, the collector, leak this information without getting the permission of the person who gave this information, it's an offence under section 10.
Right.
Now, when you look at Personal Data Protection Act, number 9 of 2022, also that you can see some similar provisions are there.
I think I want to get into the specifics on Personal Data Protection Act as well, and there's some areas that I want to clarify when it comes to the Online Safety Act also. But before we speak about any of those developments, we do have to take a short commercial break. You're watching Law, Land and Liberty here on Other Derana News Channel. We'll be right back after this. Please stay tuned.
Hello, my name is Himadya Sydney and I'm a student in Gautam Balika Vidyalaya, Colombo. So my question is, on the current context, how effective are the existing legislation?
Welcome back to Law, Land and Liberty here on Other Derana News Channel. We're in conversation with Dr. Sunil Abeyratne in discussion relating to the latest developments of cybersecurity and its related laws in Sri Lanka. Thank you very much, Doctor, for the previous segment. I believe that unfortunately, I had to interrupt you when you were going to help us understand the similarities that the Computer Crimes Act actually has with the Personal Data Protection Act. Before we go into the Personal Data Protection Act, I just want to make a slight clarification, which is to understand whether white hacking as a profession exists in Sri Lanka legally. What are the grounds of that? Because that is a curious question that we have received multiple times as to understanding if there is a grey line there, or if the PDPA and the Online Safety Act actually prevent that from being grey and it's black and white. Can you help us understand that, Doctor?
If anyone collect another person's personal data, now this act is in operation. Our enforcement part, of course, we have to wait a little time. Anyway, the act is already introduced. There is a way to collect this personal data. That earlier, this was not there. So directly that the provisions are there under either Computer Crime Act or other penal code provisions. But now it is clear under Personal Data Protection Act how to collect personal data. So therefore, now actually, Anuradha, there's nothing to draw a line now because the provisions are very clear. if anyone take another's personal data, now sometimes this can happen. Of course, we have to draw a line here. Data collector collect data under impression that it is not personal data. It's ordinary data, normal data. Then data subjects, that means data subject means the owner of this personal data. He can intervene and say, look, that you collected my personal data. Then that is the interpretation that one has to take that. Sometimes you have to go before legal authority and get this interpretation. If the data collector has not collected personal data of the person, or not only that, there are some exceptions also there. If the collector collects this personal data for household purposes or personal purposes, then it is not an illegal activity. So there's a judgment called Judnik versus Double Click. This is a principle come from that judgment. Even this is what other countries also introduced. If the data collector collects data for this personal matters and household purposes, it is not an offense. So likewise, when you after collecting personal data, those 7 principles are there. I think I have already explained these 7 principles in a previous occasion. I will not I don't need to explain these 7 principles again and again. So it is very, very clear if a person, after collecting personal data with the consent of the data subject, then once again Act explain what is the type of consent the data collector must get to collect various data, type of data under Schedule 1, 2, 3, 4 like that. After collecting, if the data collector collected additional data, it is the duty of the data collector to return. Or if the data collector collected this personal data to maintain particular agreement, if the agreement is over, then we must return. Then that is called data storage. Then after collecting that, as I explained to you earlier, that he must give the maximum protection for that. It is there under Computer Crime Act as well, but it doesn't explain it is as a personal data. It's common to all data, but here it's a personal data. Then it says data subject is entitled to find out what is happening to his or her data given to this data collector, whether he processed this data properly like that. And the data collector can't tarnish the good image of the data subject. So these are the principles comes under Data Protection Act, because we hired these provisions from the data protection regulations in European Union.
Yes.
So then, now it is easy to draw lines because this is a guidance to the law enforcement authorities mechanism and to the courts.
Exactly.
How to decide whether the person has violated these provisions or not.
Yes, and very rightly, as you mentioned previously, relating to the Online Safety Act as well. At the current moment, I believe that is the act that is undergone serious public debate due to its implementation, the process of its drafting, all of it has been come under question, and we've done previous programs on it as well. From a cybersecurity and a legal perspective, exactly how, what kind of role does the Online Safety Act play? Specifically, does it significantly differ from existing legislations like the Personal Data Protection Act and the Computer Crimes Act? How exactly does it distinguish itself, Doctor?
So the issue here is, Anuradhi, these acts are not local acts. Why I'm saying that? Because this is nothing to do with personal laws, because we are using computers manufactured overseas.
Yes.
We use the internet. So then we must have a proper research to find out how other countries deal with this issue. And we must hire these professionals from other countries if we use these machines and the internet relevant to the entire world. If you are going to satisfy all 4 corners, then it is very difficult to bring the particular piece of legislation. Of course, you have to satisfy everyone. The problem is, first of all, we must understand once again the nature and behavior of this subject. If we delay to bring laws to the country, so then definitely wrongdoers will carry their wrong activities. We can't stop it. This is what has happened to the country. Every day we get complaints. Some people have misused Facebook or other social media account. Then we can see some people, they have attacked the bank websites and took money. So these has become a daily news now. Now this is happening because we don't have the proper cybersecurity. So cybersecurity means that you mentioned that we don't have the single piece of legislation relevant to cybersecurity. Even with other provisions, of course, we can deal with this better. But only thing is, considering the development of technology, without any delay, we must bring to counter these attacks, we must bring relevant laws and regulations. So debates may be, okay, this is good that there must be debate because it's relevant to all citizens of the country.
Definitely.
Issue is here. All right, what is the debate? We have freedom of expression, freedom of speech. Then because all citizens, they have that right, not only accused or suspects. We have to seriously think about victims as well. So we have to balance the situation.
Exactly. Now, the Online Safety Act, apart from which, now when it comes to relevance to the general public, I believe that is why the Online Safety Act took so much center stage, because it basically, there was dictations relating to conduct on social media as well. In your opinion, Doctor, could you please tell us exactly what you believe is the most contentious area when it comes to the Online Safety Act? What do you think is the most salient or the most significant part or point or clause in the Online Safety Act? What do you think caused so much contention?
As far as this online platforms, so social media platforms concerned, that's a serious threat to privacy. This is the main issue. There's impersonations going on. There's privacy issues are there. On one hand, we have the Personal Data Protection Act, that we can control that up to a certain extent. But we must not forget the fact that most of the wrongdoers, they are not in our country. They upload some materials from overseas, other countries. Some countries where they are residing, there are no proper basic laws relating to computers and network. We must not forget that part. So under these circumstances, if we have to strengthen this legal framework. Now, if I answer to your questions, Anuradhi, this is high time to think about artificial intelligence as well and big data.
Yes.
Most of the acts deal with big data. Big data in the sense now today computers are very efficient. We have a very powerful database. We call this a 5E's in all in that, because as far as computers, today's computers are concerned, compared to 1990s, volume is high, velocity is high, veracity is high, value is high, everything is high. So this is what we call the big data. So at the moment, when you look at this big data, since we have very high-powered database, we have to expect this violation of especially that personal data. Now the worst situation is, now we are living in AI era. When it comes to artificial intelligence, who take the responsibility for these violations? So there are lots of mechanisms in other countries. So without a delay, that we must hire these legal provisions to our country and introduce these acts. So this is how that we can combat against misuse activities in cyberspace.
Definitely. And we have to get the specifics relating to what we can expect when it comes to the biggest challenges when it comes to cyber law in Sri Lanka, and also how critical infrastructure will be impacted and how we are faring at the current moment against the already existing strong cybersecurity systems. But before we go in for a short commercial break, one single question I'd like to ask you is, Doctor, relating to e-commerce and digital transactions, we have an act in place. In your opinion, Doctor, is the currently existing act inclusive of all areas that it could consider when it comes to safety of transactions online, or will there be issues that need to be mended?
If we purely give interpretation for online transaction, yes, solution is there. But when you look at electronic commerce, the development of consumer protection also must be part of it. It is not a part of our e-Transactions Act at the moment. So there we are going on a different line. So we have to amalgamate both. As far as now take example, distance selling. Now when you take distance selling, there's nothing to do with e-Transactions Act in Sri Lanka. So there are some regulations introduced to Consumer Affairs Authority. Act. So if we can bring some legal provisions to either to CA Act or E-Commerce Act, or if we can add one chapter relevant to e-commerce transaction, then we can fulfill certain matters. So what we can see is that basic principles are there under E-Transactions Act. So as far as the development of misuse activities, we have to place big question mark whether it's enough or we have to bring more provisions to strengthen this act.
Definitely, and that's why communication and conversation is important as well, so that we can draw attention to these kinds of issues and hopefully have policymakers pay attention as well. Before we go in for the final segment, I hope that we can get to the specifics relating to what we can expect for the future of Sri Lanka's cybersecurity segment. Let's take a short commercial break. You're watching Law, Land and Liberty here on Other News Channel. We'll be right back with the final segment, so please stay tuned.
Hi, my name is Amasha Lianage. I'm a second year undergraduate in Management and Leadership at an IBM School of Business. My question is about the future. Can we expect better legislation moving forward?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Dr. Sunil Abeyratne. We were just getting done speaking about the specifics when it comes to the Online Safety Act, the Personal Data Protection Act, e-commerce, e-transactions, and exactly what's missing. I think that's the perfect segment for us for us to kick off this final part as well. Doctor, as you very rightly mentioned, there needs to be a lot of conversation and there needs to be more effort made in relation to the development of this area. Specifically now, since we are in our final segment with future-focused responses, Doctor, as a member of the National Law Commission as well, I'm sure you'd have some sort of insight into exactly what is required for Sri Lanka's current digital landscape in order to ensure cybersecurity through legal means. If you could walk us through some areas that have currently come under conversation and have been discussed and what we should be paying attention to right now.
Anuradhi, last year, Sri Lanka also signed Hanoi UN Convention related to cybercrime. This is very important because what we can see is under Hanoi Convention, they have identified what is electronic evidence. Up to October last year, until they introduced this Hanoi Convention, there was no proper interpretation given for electronic evidence. So this is very important because our evidence law come from the Commonwealth legal mechanism. There we are subject to various principles, unlike civil law countries. So therefore, that identification of this electronic evidence is very important because it's very, very serious matter because time won't permit me to explain everything.
Unfortunately, there. Yes.
So when you look at this, of course, not only that debate is going on, it will take another couple of months to settle around this convention as well. So this is a good development. Now, based on that, because this will become an international obligation thereafter, since we are a member country, so then we can reshape. We can reshape our existing provisions relevant to Evidence Special Provisions Act or E-Transactions Act or amendment brought to Civil Procedure Code or that future amendment we are planning to bring to Criminal Procedure Code. So then we can overcome certain situations. So then in addition to that, at the moment when you look at Computer Crime Act, now we can see there are some issues, red tapes are there. We can't bring these matters before courts. When you look at this institution of cases under these acts, because it is at a very low level. Now we have to identify what is the issue to bring wrongdoers under these acts before courts. So law enforcement is a mechanism. That's the mechanism of any criminal justice mechanism. Law enforcement mechanism is very important. So if we can't bring these matters before court, there is no point in having these acts. It will be only academic purpose then. So then we have to reshape some provisions to bring this Act, especially Computer Crime Act, as a practical piece of legislation. That is number one. Number two, when you look at e-commerce, or we have e-Transactions Act, it includes e-commerce and non-commercial matters like in Singapore. Now, once again, there are some issues involved in that. Most of the countries follow these provisions for commercial matters. They call this piece of legislation also as e-commerce act. So when you try to apply these provisions for non-commercial matters, once again, there can be some other issues. So best way to separate this act. Some provisions for commercial matters, some provisions for non-commercial matters. It is not a very difficult task. You can do it. Then we can, like a code, we can introduce e-Transactions Act, some chapters relevant to commercial matters, some chapters non-commercial matters, a couple of chapters or one chapter relevant to consumer protection. And if you want the part of data protection also, if you like, you can bring. Anyway, I am happy to maintain this data protection act separately.
Right.
Then once again, when you come to personal data protection act, there's lots of policies we need, especially now take example, especially this relevant to medical profession. When they carry some research work, sometimes they have to send some materials, personal data of their patients to other countries to get better opinion for research purpose. And they have to get down some personal data of those countries or to our country as well. But that is why some exceptions are there. If the data collector collect personal data for scientific, archaeological purposes, statistical purposes, it is not a violation. In the data, when you come to limitation also, sometimes if the data subject direct the data collector to now remove this my personal data, now my contract is over, my mission is over, purpose is over, still the data collector can keep this, considering those factors I mentioned. That's the exceptions there under Personal Data Protection Act. So in addition to that, it is high time to activate this act and this amendment brought last year.
Yes.
They're following some international concepts. Then I can't agree with the delay of bringing the Cybersecurity Act, mainly because when you look at part 3 of Online Safety Act, we can see the very strong offences are there. What happened was we removed criminal defamation chapter from our penal code.
Right.
So during that period, we didn't have the issues on social media. We removed that chapter. But if we had that chapter,
Yes.
we would have easily deal with these matters. Now we are struggling to bring the same offences back. Now it is very difficult.
Yes.
Sometimes media also might object definitely. So this is the issue.
There's always an issue. Now, one question I wanted to ask you as well, Doctor, is the importance of conversation around this kind of topic. The ICT Law Conference is going to be happening at the beginning of August as well. Why exactly are conferences like these significant and important in order to ensuring that the communication around the need for cybersecurity legislation doesn't die down?
Andradi, during last couple of months, we heard lots of misuse activities through these banks. This is what happened to some leading banks. And every day we can see the breaking of laws and how the victims, what they say is their grievances. Considering that, this time ICT Lawyers Guild of Sri Lanka decided to organize their annual conference on legal impact on cybersecurity. Professor Ian Walden, the head of the IT department of University of London, Queen Mary College, he's coming to give, he will address, he will deliver the keynote address. And Mr. Atul Harilal from Singapore, he's a cybersecurity expert and cyber tool expert. He's coming to conduct another session. So likewise, Mr. Rohan Chandragupta, likewise some scientists, they will address. In addition to that, a number of Supreme Court judges and Honorable Solicitor General and leading practitioners in this area, they will address. We are, when Honorable Ministers also will be attended, we want to get down all stakeholders to one table and resolve this delay and to discuss how to overcome certain situations, how to bring this relevant laws, policies, regulations to the country in a speedy manner.
Exactly.
This is the expectation of this conference.
Exactly, and hopefully that can come into fruition as well. Final question, Doctor, before we have to end off on this discussion. Is there anything specific you'd like to leave the general public, the viewers, with when it comes to understanding the legal rights and the rights awarded to us when it comes to the digital space? Is there something you want to maybe as a final comment to let the viewers know?
Especially, we must understand we have basic legal framework at the moment in this country. There is no doubt that we have to strengthen this legal framework. In the meantime, you must know how to protect your device and how to protect your transactions. I will give you one example. When you open your mobile, most of the mobiles are now smartphones at the moment. You will be connected internationally the moment you switch on, or the moment you connect your device, computer, to the internet, you will expose to the entire world. Before that, think twice. Now you will be exposed to the entire world, means that you should know how to maintain your security, protection. If you feel that you are unsecured, think twice before you use that device or system.
Exactly. Just a little bit of critical thinking will go a long way. Unfortunately, that's all the time we have on this discussion. Thank you so much, Doctor, for taking the time to come to the studio here today and to help us understand the legal impact that Sri Lanka's legislation has when it comes to cybersecurity and our digital landscape. We really appreciate it.
Thank you very much for inviting.
All right, well, we leave you tonight with the words of Ma Hua-teng. There should be order if the development of the cyber world is to be sustainable. That's all we have for you tonight on Law, Land and Liberty. Thank you very much for watching. Have a great night.